Could you revisit what you have indicated in your presentations on behalf of the people that are watching and listening to what you have to say in regards to how the Aboriginal will be impacted on this? And if you have some solutions, other possible solutions, rather than doing it this way, I would also like to hear those.
Well, unfortunately, I don't have any stats or particular information about the impact of these specific drug laws on the Inuit community. So I don't know about the rates of participation in drug production, drug trafficking, importing and exporting, in the northern communities. I can say that certainly in terms of thinking about Section 15 and discriminatory effects, we do know that the rates of incarceration of Aboriginal peoples in the north is actually at the highest rate of incarceration in the whole country. So we do know that. I think we also could expect that the impact of imprisonment for people who are being taken out of the north and sent to the south to prisons will be a much more harsh and debilitating impact. 718.2E of the Criminal Code is supposed to give judges this push, to consider anything other than imprisonment, if at all possible, for Aboriginal offenders. And interestingly enough, the greatest beneficiaries of that provision appear to be non-Aboriginal people. So,
Could you elaborate on that? What do you mean by that?
Well, I'm quoting from some research by, let me just get to my page here. I'm quoting from research by Julian Roberts and Ron Melchers, I think. And they found that where am I here? They found that after the 1999 decision that the main beneficiaries of the sentencing reform appear to be non-Aboriginal offenders who experienced a decrease of 22% in the rate of admissions to prison. Whereas for Aboriginal people, their rate is actually increased in terms of admissions to prison. Right. So, the sad fact is that even discretion does not necessarily work to the benefit of Aboriginal people, but you can be sure that a non-discretionary measure, mandatory sentences, will absolutely increase their incarceration. So, it's not all that positive a lesson if I can't tell you with any certainty that 718.2E helped Aboriginal people, but you can say with certainty that the new mandatory sentences will increase the numbers who go to jail. And I guess the other thing I would say, even though the sentences proposed in C-15 look short compared to some of the sentences our judges currently hand out, and certainly look short compared to U.S. sentences, we're still going to see the same effects. You're going to have people coming out of jail who have to reintegrate with a criminal record and the destruction of the human personality that goes along with imprisonment, and the loss of their families, their jobs, if they had them, their communities. So I think what you do then is create an even more vulnerable group, a group that's even more prone to participate at the outsides of society and perhaps in illegal activity. So even short sentences are extremely debilitating for individuals and populations. Have I answered your question?
Yes, Senator Watt, I'm going to put you down for a second round if we have time for one.
Thank you.
Senator Baker, suivi par Senator Carignan.
Yes, Madam Chair, thank you. I'll just ask the question to each one of you first. Mr. Plecas, you directed your statistics to British Columbia and Alberta, but I can assure you from our reading of case law that you would have to agree that one of the principles of sentencing is similar sentences for similar offenses for similar offenders in similar circumstances. And that applies to all adjudications in our courts, and is fairly consistent across the country. And unless you could, somebody who's convicted of a possession crime, of course doesn't go to jail for the first time. Of course they don't. And judges structure the jail term to somebody down here, to somebody who's carrying, to somebody who supplies, to somebody who produces. And, of course, you find a variance in sentencing. You've got to be just about it. So that's my question to you. My question to Professor E.Sheehy is this. You have established, no doubt about it, a violation of Section 15. However, that doesn't make the provision unconstitutional. There's an additional step that you have to go through. If you listen to Mr. Plecas, then you would lose your proffering that this is an unconstitutional measure, in that it would probably escape under Section 1 of the Charter. So whereas you establish that it violates the Constitution, that's only the first step, as you would agree. But if you listen to Mr. Plecas, you would lose then on your argument as to whether or not it's saved by Section 1 of the Charter. And I'd like for you to comment on that.
Who's going first?
Go ahead,
Would you like to go first?
Sure.
Okay.
Again, I'm sorry, the question I gather is whether or not I would agree with that there's quite properly variation in sentencing?
Yes, and also sentencing is a consistent thing across the nation.
Yeah.
Judges, lawyers just don't look at what happens within their province, but across the nation in sentencing.
But I would say, and I don't know how I could say this stronger. If judges are supposed to be consistent in their sentencing, and if they're supposed to be guided by what's happened in previous sentences, and as legal scholars tell us, especially if we're talking about light crimes, there is no evidence whatsoever of that, and just the opposite is true. Absolutely the opposite is true. I would challenge anyone to look at any collection of cases, at least in British Columbia, and overwhelmingly, judges fail repeatedly to take into account people's prior record. We found that in our research on drugs. I find that whether we're studying auto thieves, whether we're studying domestic assault, whatever, there is just no evidence. We think they're supposed to do that, but they just do not do it. And in fact, my friend's concerns here about the treatment of Aboriginals, I think that should be one more thing which tells us that judges haven't been able to even handle that.
Could I just interject?
Which do you want, Professor Baker? Do you want a supplementary now and then hear Professor E.Sheehy, or do you want to let Professor E.Sheehy respond?
No, Professor E.Sheehy.
Well, my response under Section 1 would be to argue that it's a failed project, that in fact the goals advanced by these laws cannot be effected. And I think there's a lot of evidence to support that proposition. So, you're right, could pass under Section 1, but might not. There's certainly a case to be made that these are not demonstrably justified in a free and democratic society, given in particular the anti-democratic effect that they have.
Just a very short